Good afternoon, everybody. Welcome to the private children's seminar run by Guildford Chambers this evening. It's the 18th of October today. Just for those looking at the webinar not live. I'm going to take you through the private children updater today. It's going to cover largely issues of domestic abuse and where we are following on from HN last year. At the end, there's going to be some further exploration of some ancillary matters, including one or two issues in relation to port alerts and psychological experts. But I hope not to detain you for too long, so let's get cracking. The first case that we will consider today is the case of B&B, which is reported at 2022 EWHC 108. It's a decision of Mr. Justice Cobb, and it's one of the conjoined appeals reported following re-HN. In very short terms, factually, the mother, who was in her mid-20s, had arrived in London in around 2015. She was described by the court as naive, unworldly, and in the circumstances, a very vulnerable young woman. And she had led a sheltered life in Kent, where she had come from. The mother in this case alleged a range of allegations against the father, including abuse of alcohol, cannabis, cocaine, and that on more than one occasion he had forced her to take cocaine as well. Secondly, that he had controlled her financially, relying on her income to support him, that he'd been verbally and physically and sexually abusive towards her. There was a further allegation that he wanted to know where she was at all times, and that he was otherwise unsupported, unfaithful, and in many other ways irresponsible. Mother's oral evidence was less than impressive. She was confused over dates, particularly the sequence of those dates and events, and the father had attributed this to a fundamental lack of honesty. This is not a view that was shared by the judge. The father's case was that the mother was also verbally and physically abusive towards him, that she was mentally unstable and threatened him with, and threatened to harm herself with medication and knives, that he asserted that she was obsessive about him, repeatedly accusing him of cheating and checking his phone. And that she was violent as well. This was a very short relationship, lasting only 2 years. And after the relationship ended, which was about 3 years later, mother for the first time alleged that the father had sexually assaulted and or raped her multiple occasions during the relationship, often following an argument, during which he used force on her and refused contraceptive protection. She also alleged that he had unlawfully imprisoned her, by friends of him rather than him himself, for a period of 24 hours. The judge found that the mother had deliberately misled the court about a further allegation that the father had been responsible for malicious communications towards her in 2017. The judge found that there was a power imbalance between the relationship between father and mother, and the father had caused the mother to live in a state of worry and anxiety, and was satisfied that the father's behaviour went well beyond the quote, directive, assertive, stubborn, or selfish behaviour, which is occasionally seen within relationships. And that the father had cynically paid little heed to the vulnerabilities of the mother as an imminent and his responsibilities as an imminent father. He further exploited the mother's naivety, relative youth, and was patronising and dismissive of her. The importance of this case is the very helpful summaries provided by the judge dealing with the fact-finding exercise. Significantly, and I'm following on H&N, the judge said, firstly, paragraph 6 of the judgment, for those of you who will go on to read it, that the court will need to consider the evidence in relation to each form of domestic abuse, but in clusters, which makes it much easier to see whether patterns of behaviour emerged. Secondly, that delay in hearing the evidence compromised the quality of the evidence as well as taking its toll on the parties. The arrangements needed to be flexible to ensure that the participation directions truly met the needs of the parties and the case. For advocates such as ourselves, there will need to be a focus on the issues that are necessary to determine. Submissions and oral evidence must be cut down to what the court needs to hear. In a very polite judicial way, keep it short. Similarly, the evidence of the parties themselves are always likely to be far more valuable than that of third parties. Judges must rigorously test what real value additional witnesses will bring, what I have called the evidential third wheel. Unsurprisingly, the judge also said that judicial continuity is important in domestic abuse cases. In this current case, it had enhanced the efficient and sympathetic management of the process. And importantly, he recognised that an abusive relationship is invariably complex, in which the abused partner is often caught up in the whirl of abuse, losing objective sense of what is and is not acceptable in a relationship. And that is something that, of course, every advocate will look for. Significantly, later on in the judgment, between paragraphs 26 and 30, he went on to distill the relevant legal principles that should be applied in all domestic abuse cases, and it is well worth reading these in full. I've listed two in the next two slides, the appropriate, in paraphrased form, pointers. Firstly, the burden of proof lies throughout on the person making the allegation. Secondly, in private law cases, the court needs to be vigilant about the possibility that a parent may be using their allegation to gain an advantage in the battle between them. Thirdly, it is for neither party to prove a negative. Fourthly, the standard of proof is the balance of probabilities, and the law operates on a binary system which needs to be applied with common sense. And generally speaking, a judge ought to be able to make up their mind about where the truth lies without needing to rely on the burden of proof. Number 6, the court can have regard to the inherent probabilities of an event occurring. The more serious or the more improbable the allegation, the greater the need for evidential cogency. 7, findings must be based on evidence, including inferences properly drawn from evidence and not on suspicion or speculation. 8, the court must survey the evidence on a wide canvas and considering each piece of the evidence in the context of all of the other evidence. 9, the party's evidence is of utmost importance, and the court must form a clear assessment of their credibility and reliability. And 10, the court must bear in mind that witnesses may lie for many reasons. And of course, there will be in those appropriate circumstances, there will be a Lucas direction sought by the person who may or may not have lied. Very significantly, the court made it clear that the family court is a completely different function from that of the criminal court. A fact-finding exercise is to determine what has happened so as to inform the welfare evaluation in respect of the options for the child or children, and that PD 12J needs to be followed. The judge significantly went on to consider the vulnerability of the witnesses, because that has significantly an impact on what a mother or father may do in circumstances where it may not feel the sensible thing to do or the reasonable thing to do. And I've set out there the paragraph 30, which really makes it very clear. You will, as advocates, need to explore why something has happened or why it hasn't happened in circumstances where to you or I it wouldn't make sense. The following paragraph is worth reading, and I will do so now simply because it is so illuminative. The judge said, "Here it is quite clear from the reading of the transcript of the hearing and judgment that in rejecting a number, although not all, of the mother's allegations against the father, the judge relied very much on the fact that she wanted to be in a relationship with the father. She tried to get him back when he rejected her, and that she engaged in sex with him after occasions when she had been raped or abused. These reasons may well hold good for many cases, but most definitely not all. In some cases, it is a very unsafe premise upon which to base a finding of fact, especially if the alleged victim is vulnerable or dependent, as the mother says she was here. Further, it seems to me that the judge's disbelief that the mother would have remained in an abusive relationship led her to conclude that the mother was lying about it. This tainted the whole of her evidence and was a thread that ran throughout the case." So, bearing in mind the clarification or the summary of in B and B, we then move on to K and K, which overtly says that this judgment is intended to provide general guidance on the proper approach to fact-finding hearings in private family proceedings, following the court's decision in Re HN. This case was the subject of a fact-finding hearing. The issues were about whether or not there was an allegation of rape during the marriage, verbal abuse, verbal and bullying exemplified by WhatsApp messages between the father and the mother on one particular date, controlling behaviour, as well as upsetting questions and allegations of encouraging the children to get into bed with the father whilst he and his partner were naked, as well as physical abuse by flicking one of the children's ears and financial control. There was at that stage no specific reasons given for the judge's decision to hold a fact-finding hearing. This is particularly important in this case because after a short pause following the separation in August 2017, there had been a regular arrangement for two of the children to stay overnight with their father in October 2017, and then again at Christmas 2017. The father then moved away in May 2018, and the children, or most of the children, continued to stay with the father. It was only after Easter 2018 that one of the children refused to go. At the fact-finding hearing, the judge found that each of the allegations had been proven, except an incident in relation to the children getting into bed and financial control. The judge in that circumstances then set out the conclusions, the summary of his conclusions on the law following that fact finding. The first is that, and as you see there, there's always a good list in some of these cases. The first is that it was unfortunate that the parties did not take advantage of the Mayam. The court in this case was very clear that the whole fact-finding exercise could have been avoided, which would have negated the need for the trauma that had been caused by that procedure. The mother had agreed to unsupervised contact and did not at that stage see the alleged rape or generalized allegation of controlling behaviour, bullying or physical abuse of the children as central to the resolution of the issues between them. Following on from Mayam's, of course, and second in this case, the court underlined that the FEDRA, as the name suggests, is primarily an opportunity for judicially led dispute resolution. Again, the C1A in this case did not profess to object to contact. It appeared to be a logistical issue rather than anything else, and that should have been explored at the FEDRA. Thirdly, it's important that a judge considering ordering a fact-finding hearing identifies at an early stage the real issue in the case, in particular with regard to the welfare of the children. They make very clear that a fact-finding is only needed if the alleged abuse is likely to be relevant to what the court is being asked to decide relating to the children's welfare. Fourthly, the findings that the father raped the mother during the marriage was unsafe because the judge failed to look at the matter in the round. He focused too heavily on the question of whether the mother had had the conversations complained about the father's contact, rather than considering all of the evidence, including various untrue assertions in the Scott schedule. Fifthly, the judge ought to have considered all of the allegations in the context of the contention that most fundamentally affected the question for future contact, namely whether the father was demonstrating coercive controlling behaviour affecting the children's welfare after separation. Sixthly and seventhly, which can be dealt with together, the judge questioned whether the findings by the court really led to or were able to sustain a finding of controlling behaviour. The judge, for example, had found no evidence of financial control, yet went on to find controlling behaviour based mainly on the WhatsApp messages of a single day. The judge had correctly found that the ear flicking did not amount to child abuse, and yet allowed his order to suggest that he had found physical abuse of all three children to be proven, when of course it had not. So those findings were set aside, and that court appealed to both parties to consider whether, even at this late stage, there should be some room for compromise rather than redoing it. At paragraph 67, the court makes it very clear that the pendulum that seems to have swung so far in favour of fact-finding exercises in HN is swinging back towards limiting that to those that are only necessary. And I've set out that helpful quote at 67. It seems that there has been a misunderstanding of the court's role has developed. There is a perception that the Court of Appeal has somehow made it a requirement that in every case in which allegations of domestic abuse are made, it is incumbent upon the court to undertake a fact-finding involving a detailed analysis of each specific allegation made. This is not the case. As HN explained, and we reiterate here, the duty on the court is limited to determine only those factual matters which are likely to be relevant in deciding whether to make a child arrangements order, and if so, in what terms. Of course, this is going to be a useful reminder for a number of practitioners seeking to defend against a fact-finding exercise. And one last thing in this case, which again, very useful for post-fact-finding analysis in any Section 7 report. The judge has, in this case, allowed a CAFCASS report to paraphrase his detailed findings. And he says 85, there is in our view a real danger in reducing bespoke, detailed and subtle findings made by a judge to one or two words, headline labels in the place of the original detail. This case analysis uses labels of rape, bullying, manipulation and psychological abuse, each of which emits a neon light in an erroneous and unjustified manner. That, no doubt, will be a sore feature of some cross-examinations on the basis of the weight given to each of the areas of findings by a Section 7 report author. Again, a helpful feature of any submissions that you might need to have. We then move on to B and P. And this picks up where the assessment of vulnerability left off in our earlier case. But as a function of vulnerability as a function within a fact-finding exercise. In this case, the proceedings concerned two children, age 7 and 9, and effectively an application for enforcement of a child arrangements order. The mother counter-applied for a variation of that order, making allegations of domestic abuse. The mother was represented and the father was not. There was a fully remote fact-finding hearing where the judge heard oral evidence from the parties, the mother's brother and the social worker. There was no ground rules hearing, nor was there a consideration of any special measures. The court in those circumstances had not been referred to the need for a ground rules hearing, hadn't been referred to Part 3A of the FPR, Practice Directions 3AA or PD 12J, nor was there a reminder of Re-HN. Notwithstanding all of this, and perhaps not surprisingly, the judge found most of the mother's allegations were not proved. Most of the father's allegations against the mother on the enforcement application were proved. So the mother appealed. There were significant findings against the father, which should have led the judge to consider whether or not his behaviour was coercive or controlling. The appeal court had found that the father had called the mother a number of abusive names: fat, lazy, pig, donkey, and so on and so forth. But that did not then move beyond that analysis to whether it was coercive or controlling. Similarly, there was a failing in that the judge had not then gone on to consider whether there was a pattern of behaviour and whether, given those findings, the respondent was more likely to have been abused by the applicant in similar ways as alleged. The trial judge had also failed to appreciate that what had been found, the name calling, amounted to abuse. At its highest, it had been referred to as unpleasant things being said. There was no consideration thereafter of the impact of the admitted verbal abuse on the children, even though that had been accepted to have been done in their presence. The judge had found that the father had sent messages to the mother during their relationship, which clearly included threats made against the mother. These were clearly threatening, but the judge found that these were simply not ideally worded, which is clearly fails to take on their importance. So in those circumstances, the appeal court found that the judge did not follow the correct approach in H&N, stepping back from the precise allegations and considering the behaviour as a whole, and whether there was a pattern of coercive and controlling behaviour. Had the judge stood back to consider the evidence as a whole, rather than simply making separate findings on each given example, she would have found the father's behaviour would have formed such a pattern, and that the result being that the judge minimised the father's behaviour. Those errors were compounded by the failure to consider the various practice directions on vulnerability and domestic abuse. Whilst there was some efforts at the judge putting questions on behalf of the father, the execution of that procedure was lacking, in that often the father addressed the mother directly. And so the participation directions had not been properly implemented throughout the course of the hearing. In those circumstances, the findings were set aside. Then moving on and on to the post-fact finding arrangements. The case of Griffith and Griffith, Arbuthnot J, allowed an appeal against an order for direct contact made by a circuit judge at the dispute resolution hearing, on the basis that the judge had not given sufficient reasons for dealing with the requirements of PD, when dealing with the requirements of PD 12J. There was also consideration of the court's power to direct who should pay the costs of contact supervision, and how the court should allocate the responsibility when there had been findings of domestic abuse made against the person seeking contact. Miss Griffith had established that she had been the victim of domestic abuse, including rape, physical assault, coercive and controlling behaviour during the marriage. The parties separated in 2018, and the father was having contact by agreement in 2019. He applied for an order in June 2019 following a breakdown, and the contact was ordered in a contact centre, and that father was to pay the costs. The father had applied to change the arrangement, including the costs, as he was unemployed and the mother had income. In May 2020, it was ordered that the costs should be shared equally. There was a DRA, and the judge at that occasion ordered that the direct contact resume at the contact centre on the same terms again, and directed a psychological assessment to the father. The mother appealed the decision to order the resumption of contact and in relation to the costs. Arbuthnot J identified three questions. First, whether in principle the court has the power to order a party to pay for the costs under section 11.7. Secondly, whether the judge was wrong to order direct contact in the particular circumstances of the case. And third, whether a victim of abuse should pay the costs of contact for the abuser to have contact with the party's child. The court rejected the mother's argument that there was no power to order to pay costs. The court found that there was such a power under section 11.7. In answer to the second question, the judge found that the trial judge had allowed herself insufficient time to properly consider and explain how she had applied PD 12J. That hearing was listed only for an hour. In particular, the failing was that that she hadn't explained how the contact arrangements in PD 12J had related to the findings of harm. Dealing with the allocation of costs, the judge said that although as a matter of they had not envisaged a situation where the court would order the victim to share the costs of contact. The caveat to that is that, one, there must be a very strong presumption against a victim of domestic abuse paying for the contact of their child with the abuser. Secondly, if, wholly exceptionally, the court has to consider this, the matters that the court might want to have regard to should include the following: the welfare checklist, including the age of the child, the factors in PD 12J, the nature of the abuse proved or admitted, and the party's conduct that the court considers relevant. D, the impact of the abuse on the caregiver with consideration to whether any payment would give rise to financial control. E, the extent of the relationship between the child and the abusive party. The nature of the Section 8 order made, the party's financial resources, the cost of the contact, and whether, if the contact is in the best interest of the child, it would take place without a sharing of the costs. Well, sorry, ladies and gentlemen, I seem to have rode along in the presentation. I'm sorry about that. Let me see if I can go back to the right page. Here we are. Here we are. So where does that then leave us following on from domestic abuse findings? Well, the classic answer is that there is a domestic abuse perpetrator program course, which involves two stages. Firstly, a suitability assessment, and then an order for the domestic abuse program, which in itself has usually interim and final reports. All well and good, one might say, except the family court advisors can no longer recommend the perpetrator programme to the court, as referrals ceased on the 30th of June this year. The Ministry of Justice apparently has decided to work towards replacing the existing DAP with a new programme. Unfortunately, they haven't produced the new programme, and it's not clear when that new programme is or when it will be available. It seems not until at least 2024. The difficulty then is, what does the court and the other parties do in relation to addressing the behaviour that has been found, particularly in circumstances where the perpetrator accepts that finding, which would obviously usually lead to a successful, hopefully, completion of the DAP course. Well, very little information has been provided as alternatives for the DAP course. As legal advisors, your clients may wish to consider a number of other options, none of which are particularly cheap or, sadly, particularly quick. On occasion, I have known that there's an order for a risk assessment by CAFCASS, either before or after some form of intervention. You could, for example, consider the possibility of a bespoke expert therapy, although the cost may be prohibited. You could, certainly there was, availability for private DAP courses. The difficulty historically was that CAFCASS refused to endorse those private DAP courses because, in short, they didn't run them, and so they couldn't assess their effectiveness. Of course, they don't run any courses now, so it may be that that is the only choice available. It does put your clients in an invidious position. It also puts the victims of alleged abuse in an equally difficult position in terms of assessing whether or not there continues to be a risk or not. We wait to see what the answer is, but in the meantime, some imaginative thinking is going to be required by the legal advisors put in that position. So moving then beyond the issues of domestic abuse, we then have the case of A, B and C, which is the nesting arrangements, 2022 EWCA Civ 68. This is a case where the court, Lord Justice Warby, commented on the nesting arrangements. And if you didn't know, a nesting arrangement is the converse of the classic shared care arrangement, in that rather than the children moving between two households for a period of time, instead it's the parents that move between the same house and the children remain living in that home. In this case, the parties separated in 2018. At some point thereafter, an interim arrangement was reached, creating what was described as a 2255 nesting pattern. The father's case was that this agreement was reached because both parties considered it in the children's needs, and the mother considered that it had arose out of financial necessity because she was unable to afford alternative accommodation. In May 2020, an interim arrangements order was made, providing for the nesting arrangements to continue following the March 2020 lockdown. Significantly, each parent gave an undertaking not to remove the children overnight during their own period of care, unless otherwise agreed or ordered, and also to vacate the home during the other's period of care. During the following proceedings, at least 3 independent social workers were instructed, the third being Dr. Nicholas Dinich. He had recommended that the phasing out of the nesting arrangements, although accepting that it was against wishes and feelings. Excuse me. His evidence was that, quote, in his experience, the nesting arrangements work well and could be of benefit to all when the parents were in accord. He experienced such arrangements when the parents continued to be in conflict and where the children remain exposed to the same. He was not aware of such arrangements where parental conflict and discord remain in place or afford good outcomes for the children. He expressed concern that maintenance of the current arrangements, that is the nesting arrangements, will further harm the quality of the children's relationship with their mother in this case. And whilst any new transition to a new arrangements would present challenges, the difficulties associated with the transition will be less significant than the ongoing harm experienced by the children if there was no change to the arrangements. The court in those circumstances made an interim order that would move from a transition from the nesting arrangements to a shared care arrangement in the classic sense. There was an appeal on the basis that the judge was wrong to proceed to determine the interim arrangements for the children in circumstances where it was in fact an interim arrangement, that the judge had not been impartial, and that the judge was wrong to conclude that it was in the children's interest for the existing arrangements to be changed at all or at this stage of the litigation, and to impose the week on, week off arrangements in circumstances where the child did not support the change. The significance of this case is, of course, that the strength of Dr. Dinich's argument in relation to the positive benefits of the nesting arrangement. The court in that order did not find Dr. Dinich's conclusions to be anything other than sensible. he said at paragraph 33, the view expressed by Dr. Stintage about nesting arrangements could hardly be said to be controversial. And the judge's observation were, to my mind, equally unobjectionable. The consideration about whether or not that order should be made on an interim, or the transition order should be made on an interim view, was that was really only a modest departure from the previous arrangements, and it leaves open the possibility that the court may endorse the extension of the nesting arrangements in some form after the final hearing. It was a measured and proportionate conclusion with which the appeal court did not feel it could interfere with. Nesting arrangements clearly work in some cases and not in others, and in circumstances that are not dissimilar to the failings and limitations of a shared care arrangement. Significantly, in this case, it appears that the nesting arrangements have been approved or come to by way of an agreement implemented by an undertaking. The question that arises is whether or not the court can make such an order in circumstances where that agreement is not forthcoming, or in circumstances where the agreement is looking to be resiled. There are obviously dicta in relation to relieving a party of an undertaking in circumstances where an order isn't possible, and it may be that the court simply would not release that child, release the party from the undertaking to vacate the family home. Significantly, previous authority has made clear that an ouster injunction does not fall within the purview of the Section 8 order, and the authority that is relied on that is K Child Contact Ouster Injunction 2011 EWCA 1075. And so in circumstances where there is no agreement or no pre-existing order which have been agreed to, the court may find nesting arrangements simply not within its armoury. We then come on to a slightly different issue in relation to experts. The interim guidance has been issued by the Family Justice Council in May 2022, which deals with expert witnesses, alienating behaviour and conflicts therein, particularly addressing issues of conflicts with psychological experts. This comes very much on the heels of last year's guidance from the President in relation to experts on the family court. That guidance made very clear that the court should be relying on a body of knowledge that is widely recognised, and the court would be should be very cautious not to rely on pseudoscience. So the current guidance, sorry, interim guidance issued by the Family Justice Council today deals with, in May 2022, deals with the possibility of conflict. That is where there is a potential conflict of interest between treating and expert assessment. In those circumstances, the court should, the guidance says, expect a range of options in psychological opinion and recommendations that are A, transparent as to the intervention and requisite qualifications needed to effect desired change. 2, the interplay by a wide range of practitioners in the field. And 3, deliverable by any suitably qualified practitioners. It expressed concern that recommendations for interventions deliverable only by the instructed expert or their associates are inconsistent with those 3 features. It increases the risks of bias and can limit appropriate oversight of interventions and risks delay, which create a barrier to families accessing appropriate, timely local support. and the court should be extremely cautious when asked to consider assessment and treatment packages offered by the same link provider. It then goes on to identify the areas in which how and when conflicts can be avoided. Particular attention should be paid to PD 1225B 9.1, which requires the 4 declarations that are mandatory, as well as the statement of truth. 2, the letter of instruction would require careful consideration of the narrative and questions put in the instruction. And 3, the scrutiny of recommended other work. I pause at this point because this is there is also guidance in relation to the expertise of psychologists within the family court system, and there is the further guidance from the on the regulatory framework for psychologists. The legislation protects 7 titles: clinical psychologist, health psychologist, counselling psychologist, educational psychologist, occupational psychologists, sport and exercise psychologists, and forensics psychologists. And that it's appropriate that the expert uses the statutorily registered practice title that appears on the HCPC register. And for practitioners, it's the HCPC register that will need to be recognised. That is different from being chartered with the British Psychological Society, which does not provide the regulatory framework as the HCPC. And lastly, there is an update on the Port Alert draft orders. This follows on from the case of AB last year. That case gave clear guidance that the court has the power to make a freestanding port alert without tipstaff, so not in the High Court. That case, well worth a read, gives the guidance on the contents of the application. The update this year is about the updated precedent, which provides a much more simple process, and a bonus for all you lawyers out there. Also tells you what to do on receipt to implement that order, which very much simplifies the provision, as it gives very clear guidance. So that is about my time up. Thank you very much indeed for all your time today. Please feel free to contact me directly or through the clerks at Guildford Chambers if I can assist with anything else, or if you have any questions. Thank you very much.